All right, everyone. So let's talk a bit more about the court system. Now, the only court created by the Constitution is the Supreme Court. Remember that wording in Article 3. The other courts are courts created by Congress. So Congress makes and reorganizes the other courts. Now, these constitutional courts, there are two types of these. There are courts created by Congress according to Article 3, and this is all of the main courts. So these other courts, state courts, federal courts of appeals, etc., all of these are created by Congress over time. Legislative courts are very specialized courts. So let's say you had a dispute over how much taxes you should pay. It wouldn't really make sense, or a dispute, or disputes about international trade. It wouldn't really make sense to have a jury of your peers decide this case, would it? Because they're not experts on these issues. So these very specialized court cases, usually what happens is a dispute is presented before a judge and a judge makes the decision. These powers are given to Congress. They're not really explicitly asked for. Congress never asked for these authorities, but it does have them. So other constitutional powers. Uh, I'm sorry. Let me pause this very quickly. Okay, everyone. Sorry about that. There was my Facebook was open and it was giving me dings. Okay, so judges serve during good behavior. What does that mean? It means that judges in the federal courts serve until they retire or they die. Now, they can be removed by Congress, but we've never impeached a judge before. Never impeached a Supreme Court justice, I should say. It never happens. Now, the idea of these appointments is that these judges, because they serve for life, they're going to be immune from the same pressures that face people in Congress or the president when they have to run for election or re-election. And that means that ideally they're apolitical or nonpartisan. They're these impartial interpreters of the law. But it's been pretty proven conclusively that that's not true. It's a great idea, but y'all, there's very little that can be done to prevent someone from bringing in their beliefs and their core values into them or into their job with them. So I think it is fair to say that there are conservative judges and there are more liberal judges. This myth of a nonpartisan judge is very comforting. And the idea that serving for life prevents people from becoming partisan is a good one. But then you have to ask one, if partisanship is indeed a factor, how do you stop that? And is one way to put term limits on judges. So, specific matter. What do courts deal with? What do the federal courts deal with? They deal with issues about the constitutionality of laws. They deal with international disputes, trade disputes, so maritime issues, controversies where someone is suing the United States, arguments between states, disputes between citizens and states. So, if you wanted to sue the state of California, your case would go to federal courts, and disputes between states and foreign citizens. So let's take a look at this organization of federal district courts. So there are 94 U.S. courts placed across the United States. Now, these courts aren't designed to be representative of any population. It's not like a congressional seat. It's not like that. It's purely administrative. So the justices in all of these courts are nominated by the president and confirmed by the Senate. And you that is true no matter if the court is in Texas or the court is in California. Now, above these district courts are the courts of appeal. So when a decision is appealed or contested, and somebody basically wants a second chance or a second verdict, it goes up to these guys, and there are 13. Now, if this decision is appealed again, it goes directly to the Supreme Court. Now, there are some special courts out here. There are the Court of International Trade, created by Congress. U.S. Claims Court, again created by Congress, and a tax court. So, federal district courts. This is where cases are first heard. These are the courts that have the first jurisdiction or the original jurisdiction over cases. Now, both of these courts, there are types of juries used in these courts. The first is a grand jury. And you hear this a lot. A grand jury is convened, and a grand jury is a little different. They're not ones making decisions on the trial, but decide whether or not a trial should take place in the first place. So usually there's an investigation, people submit these written documents, briefs based off of evidence and arguments, and a grand jury decides if there should be a trial or not. A trial jury is the one you might be more familiar with. That is a jury of your peers who decide if individuals, corporations, other plaintiffs and defendants are guilty or not guilty. Now, some cases are only heard by judges. There's not trials for every single case, but some cases are heard just by judges. Now, this is the process of appeal. So if you think something went wrong down here, you can appeal it to these courts. And if you think something went wrong down here, you can appeal it to the Supreme Court. Now, they only hear appeals from lower courts. So it's not as if these cases move horizontally. They move vertically from the bottom to the top. And you have, again, these courts are not divided to be representative. They're just administrative. So let's look at what these jurisdictions look like. So we in California are in the Ninth District of Appeals Court. Texas is in the Fifth. And you see California shares this Ninth District with the entirety of the West Coast, Alaska, Hawaii, Guam, and all of these other courts. You can count the 13 different jurisdictions or appeals courts. Again, this is a bit of a clearer map, and the District of Columbia also has its own appeals court. So these don't work the way of a law and order case kind of court. There's no new jury, no new evidence, no jury. The lawyers submit these arguments, these briefs, and a panel of judges hear each lawyer and then cross-examine them. Then the judges make a decision on the constitutionality of the verdict. They also usually publish opinions explaining why they ruled a specific way. And these opinions are published so that future courts can make decisions based off of pre-existing court verdicts. So that is interpreting the rule of law as it already exists. That is what these opinions are for, to establish decisions and for future courts to acknowledge those decisions and cite those decisions when future cases arise. So these are called stare decisis. That is what these briefs and opinions are for. Stare decisis is this tendency of following legal precedent or decisions which have already been made as the basis for ruling cases. The rulings of the appellate courts, though, these lower courts, are only valid for the geographical area they are in. And it needs to get up above these appellate courts to become a nationwide verdict. It gets to the Supreme Court then. And here we have our current Supreme Court justices. Let's see. These three were nominated by former President Donald Trump, and you've probably seen them a lot in the news, right? Like there was a lot of controversy around Brett Kavanaugh when he was accused of sexually assaulting someone when he was a teenager. Amy Coney Barrett, because she was rushed through right before a presidential election. That is something the Republican Party accused President Barack Obama of doing. Then you have other characters, Justice Sotomayor, Elena Kagan. Let's see, there's a Justice Kennedy. No, he's gone. And then there's Justice Clarence Thomas. All of these individuals are appointed for life and will likely remain in these positions until they die. Justices tend to not retire anymore, or even though they probably should. So here are our 9 justices. Now, it's important to note, because this too became a bit of a dispute, is should we increase the number of justices on the Supreme Court? Well, the Constitution says you can put in as many as you want. If Joe Biden wanted to nominate 26 Supreme Court justices, he could. The problem is getting that through the Senate. The Senate is very unlikely to want to do that. Why? Because 9 is the number that has been traditional since 1896. And usually people don't want to put in too much radical change to institutions. So, how do you become a justice? Really, there is no rule on requirements to be a justice, no rule on whether or not or who can be a justice or not. You could be a Supreme Court justice. I could be a Supreme Court justice. A dog could become a Supreme Court justice. That would make a great Air Bud movie. But there are traditions. So the first is the president nominates them, and then the Senate appoints them. It's hard to get a dog through a confirmation hearing. Most Supreme Court justices either have judicial experience themselves or they have lawyers. But the judicial philosophies of justices or potential issues become more important. So increasingly, presidents nominate justices who they believe will align with their agenda. And a lot of scrutiny is placed on these judges now. And you can even see this to this day. Senator Ted Cruz of Texas, for instance, has tried to block all of Biden's nominees, and really he seems to be grilling them on what he views to be these left-wing biases, or what he says to be these left-wing biases. Um, Other organizations, such as the Heritage Foundation, are sort of collecting pools for uh, conservative judges. And Donald Trump, for instance, really used the Heritage Foundation and the Federalist Society to try and appoint or try and select as many justices as he could. Again, here's the process one more time. Presidents pay special attention to this because they are appointed for life, and this is probably their longest lasting legacy. They do consult senators in the process. Why? Because if something goes wrong in a Supreme Court justice nomination, if a president cannot get a justice nominated, it's viewed to be extremely embarrassing. And we saw that. We saw that with Justice Brett Kavanaugh over here, who, when this revelation of an accusation against him became public, it derailed the agenda, and it was very, very, very embarrassing for the Trump administration, regardless of any bluster that they may have acted with. It's never a good thing when your nominee suddenly has a sexual assault allegation against them. That never makes you look good. So you want to involve as many people as possible in vetting these individuals because problems can occur. And when they do, it makes you look very, very bad. So the Constitution has no suggestion. Usually they're lawyers, they're judges, and oftentimes because presidents care about their legacy, this becomes a political or partisan choice. We will pick up on this. Well, no, let's go ahead and finish this. So they are nominated by the president, confirmed by the Senate, but presidents can find that this backfired. So Supreme Court justices often act with a degree of independence that presidents don't anticipate. We saw this with Donald Trump when the Supreme Court refused to hear all of the supposed election fraud cases. But we've seen it before. Earl Warren defied Dwight Eisenhower, and Warren Burger moved ahead with the Watergate investigation and allowed it to occur despite being appointed by Richard Nixon. So, we will pick up on this video, on this slide, next time.